We have reached the appointed hour. The meeting is now called to order. Agenda item number 1. Matters arising from previous meetings. On the 20th of November, the Bills Committee listened to the views of the deputations. The administration has issued a paper in response to the views given, and the paper is CB 1324/1415/01. Perhaps the officials can take us through the paper. Yes, thank you, Chairman. First of all, Chairman, the Chairman has not reminded members this. Now we have a problem with our PA system. If you want to speak, please press the request to speak button. After you have spoken, please switch off your microphone. Because we cannot switch on too many microphones at once. Yes, thank you, Chairman, and thank you, the Secretary, the Clerk, rather. Concerning the deputations who have given views, they by and large support the Uncertificated securities market system. With regard to the mode and time frame of implementation, the deputations of the view that Hong Kong should aim at mandatory uncertified securities market regime, and it's hoped that a date can be set. And after that cut-off date, investors will not hold shares in terms of share certificates. Now, when things are ready, then the USM regime should be implemented. We support the mandatory mandating paperless IPOs and launching investors' education programs. The deputations of the view that to protect shareholders, the functions of registrar and clearinghouse should follow certain rules and requirements, and we take note of that, and there are relevant provisions. In order to implement USM, there should be development of new IT systems. From the passing of the bill into law and implementation of USM, there will be a certain period of time required. The implementation of USM requires a lot of preparation. Apart from the primary legislation which is in front of you, we need to enact subsidiary legislation, and we'll consult the market. And there is also the need to raise the IT infrastructure and also the operational arrangements. We'll continue to work with stakeholders and parties concerned to implement USM, the USM regime. As for other aspects concerning operational model and rules, the deputations do give some views. As we said, the SFC will continue to work with the HKEX and FSR, or discuss with them on the details, and will draft the market on the details of the drafted rules. There will be ample time for the market to consider such rules. As for fees and charges, we reiterate our guiding principle. Principles, the fees should be reasonable, commensurate with services provided, conducive to encouraging innovation, market development, and should not offset the longer-term benefits arising from USM environment. In the future, there will be different types of accounts, and investors can put their shares in different accounts according to their preference or needs. As for the increase in number of registered shareholders, the HKICS has given a view. With the new system, the number of registered holders may substantially increase. The notices sent to shareholders and other printed matters sent by the companies to the shareholders may increase substantially and lead to substantial increase in costs. And there is a need to encourage shareholders to receive email or electronic notices. Now the rules should set out very clearly the keeping of register and also the inspection of register. These will be set out in the rules. The SFC will consult the market on the draft. As for the company's ordinance, some deputations are of the view that there should be a dispute resolution mechanism to deal with disputes arising from the implementation of the company's ordinance. Dispute resolution is a general matter. We have these disputes nowadays, and also it is not unique to the USM, and there is no need to set up a new system. As for stamp duty, we have received views from the deputations, and they support our proposal. As for the transfer and also setting up a new mechanism and also other arrangements, the $5 exemption, the $5 fixed rate stamp will be exempted. There should be FAQs prepared to facilitate the implementation. The Inland Revenue Department will issue a stamp office interpretation practice notes, and it will be uploaded to the website of IRD for reference. As for off-exchange transfers, there are certain technical suggestions. According to our proposal, the participants of the USM regime can make use of the system and announce that the transfer will have the stamp duty exempted. The details are rather technical. We have put down the details in our written reply. I'm not going over it again. Another deputation has suggested that with the introduction of the new system, the number of the shareholders of X shares will hold uncertified certificate share rather than by nominee, and we do allow them to hold shares in their own name or in the name of a nominee. As for other technical comments, we are discussing with the HKEX on their proposed amendments and to understand their concerns. As for other proposed amendments, we think that we don't need to amend those provisions because our provisions or the draft is able to reflect our legislative intent, and there's no need to amend them. Thank you. Right. Any comments from members? You may now speak. If there is no comment, or maybe a legal advisor. No, if there is no comments, then let us go into clause-by-clause study of the bill. At the previous meeting, members agreed to to study the Chinese version first, and we now proceed 101 AAL. Would the officials take us through 101 AL? is part of the Commission. It is about the issue of notice according to 101 AAK. That's the to direct recognized clearinghouse to cease operating uncertificated securities market system. And the SFC has to give the notification of the Commission's intent reason of the Commission. But if it is requested by the clearinghouse, then the clearinghouse if it is it does not apply. If the clearinghouse has requested the Commission to give the direction, or the clearinghouse has requested the Commission to serve on the clearinghouse notice under Section 43(1). The following are procedural requirements. In subclause 5, the Commission must give the clearinghouse on whom the intention notice is served a reasonable opportunity of being heard before exercising any of the powers under the Section 101 AAK 1 and 2. Then 101 AAM, certain facts or particulars to be published in Gazette, and they include subclause 1, if the Commission approves under 101 AAG1 a recognized clearinghouse to operate and maintain an uncertificated market system, the Commission must publish notice of the fact in the Gazette. If the Commission withdraws and approve granted to a recognized clearinghouse, Commission must publish in the Gazette. And third, if it gives a direction under Section 101 AAK 1 a recognized clearinghouse, the Commission must publish notice of the particulars of direction in the Gazette.
(101) is about appeals. A person served with a withdrawal notice may appeal to the CE in Council against the Commission's decision to withdraw the approval granted under Section 101 AAG (1) to the person. 2. A person served with a cessation notice may appeal to the CE in Council against the Commission's decision to give a direction under Section 101 AAK (1) to the person. 3 and 4 are some procedures. (101 AAO) is a more important clause. It's about uncertificated securities market rules. For this bill, it has a market regulatory framework, and the details are set out in the regulation. So this is an empowering clause so that the SFC can set out the relevant rules. First, it's a general clause. That is what the SFC can do concerning making rules. First, about providing about prescribed securities. This is in Schedule 3A. That is prescribed securities, and they are shares. So providing for activities matters involving or relating to prescribed securities or issuers or prescribed securities, including 1. The allotment, issue, and holding of prescribed securities. 2. The transfer of prescribed securities, including the circumstances under which the transfer may be effected without an instrument. 3. The conversion of prescribed securities in certificated form into uncertificated form. Well, according to the deputations request, we will try to look at the issue of cutoff date. So it cannot be reversed. That is, uncertificated form cannot be reverted back into certificated form. And 4, the conversion of prescribed securities in uncertificated form into certificated form, etc. And B, providing for matters relating to title to prescribed securities, including the evidence and recording and passing of such title. 2, without limiting subsection 1, rules made under that subsection, rules may provide for the following. A, the regulation of the procedures and operations of an uncertificated securities market system, or 2, any matters relating to the carrying out, execution, or processing of activities, instructions, or other things by or through an uncertificated securities market system. B, the registration of prescribed securities and registration of issuers' shares that are not prescribed securities, including registration of the allotment, transfer, and transmission of such securities or shares, the registration of holders of such securities or shares. I'd like to talk about the difference between transfer and transmission. For transmission, that is, transmission under the law is about the handling of estate. So we will use the word transmission in such cases. And C, the rights, duties, and liabilities, including the exemption from liabilities of persons responsible for keeping the registers or other records of documents mentioned in paragraph B3. D, the making and provision of statements by persons prescribed in paragraph C, and the issue of certificates or other documents by those persons. E, the ratification of the registers or other records or documents mentioned in paragraphs B3 and D, after inspection or withholding from inspection of any or all parts of those registers, records, or documents. G, the making of copies of any or all parts of those registers, records, or documents. H, the authorization of persons to engage or participate in activities involving or relating to prescribed securities. Now, what people can be authorized? For example, share registrar. I, the regulation of the persons mentioned in paragraph H. J, the consequences of the solvency or incapacity of a system operator or any other person authorized under the rules to engage or participate in activities described in paragraph H. K, the rights, duties, and liabilities, including exemption from liabilities of persons mentioned in paragraph J. L, the charging or collecting of fees by a person other than the commission specified in the rules. M, the admissibility in evidence in legal proceedings of documents specified in the rules and proof of the matters contained in these documents. And subclause 3. This is about penalties, and for the details you can see them in subclauses 4 and 5. We have set the maximum fine. For indictment, 1 million, imprisonment 7 years, and for in addition, in the case of a continuing offense, a further fine not exceeding 100 million, and for summary conviction, 500,000. So these are the maximum penalties, but of course the penalties can be lowered at this level. Legal advisor, any questions? Thank you, Chairman. I have a question about H, the authorization of persons to participate in activities. Now, this would involve market participants or share registrar. So for this authorization, does it cover the company that issue or allot the shares, or is just about market participants and share registrar? Maybe the SFC can answer this question.
It's to really just authorize share registrars, not the companies themselves.
Any other questions? If not, let's move on. Government, please. Now let us look at clause 209. Now, if the SFC, well, according to 204, 205, 206, and 207, if there is any prohibition or requirement, imposition, withdrawal, etc., then they must notify the relevant party. And for the provisions I mentioned just now, if a licensee has a problem, then the SFC would have to notify the clearing house. This is to introduce the idea of system participants. And then we will have to look at the SFO, and relevant amendments would have to be made. Okay, please continue. And then it's clause 212. If the SFC decides that according to clause 212 to make a petition asking any system participants to go bankrupt, then it will have to notify the relevant clearing house. This is also relevant amendments after the introduction of the idea of market participants. Legal advisor. Thank you, Chairman. I would like to go back a bit. Just now we talked about uncertificated securities market rules, and they would cover a lot of complicated details. And there will be a huge number of rules. So would the LegCo be given more time to look at such rules? If we use the negative weighting procedure, then we can only have 7 weeks at most, and that may not be sufficient. Has the government considered any measures so that we can have more time to scrutinize the rules? Let me tell you the background. For the SFO, Section 398, this is an existing provision. It stipulates that when the FC makes rules, it would have to issue a draft and invites the public to give their comments. And after this procedure, that is after public consultation, then the rules will be submitted to the LegCo. For 101AAO, which is an empowering clause, that is, rules can be made regarding the USM. And for clause for Section 398, that's about public consultation. That is also applicable. So we will conduct a public consultation, and we will ensure that before submitting the relevant rules to the LegCo, the SFC will consult the public, and the public can make comments and make presentations, and their views will also be taken into account. Members, any other questions up to now? Sorry, the speaker is off mic. Well, for the public consultation, yes, you may assume that LegCo members would also look at the rules during that period, but it's quite impossible. It's not that we are lazy. We just don't have the time to do it. And for negative vetting, we just have 7 weeks. So what can be done? Maybe I can supplement. Well, for subsidiary legislation, well, this is our normal practice. First of all, we will submit the paper to the relevant panel. We will brief the panel, and panel members can express their views. So for these rules, we will do the same thing because there are many technical details. Now, this has been our practice. For example, for the off-exchange derivative trading, we have a regulatory framework. And for the details, they will be in the subsidiary legislation. So in January, we will be going to the panel, and we will brief the panel on our public consultation. And after listening to the views of the public, we may amend some details. So for the rules, we will do the same thing. Mr. Sin Chung Kai, do you want to follow up? If not, let's move on. Clause 213. Thank you, Chairman. Clause 213. Injunctions and other orders. The objective of this is if the SFC has decided to make an application to the Court of First Instance and concerning an order affecting market participants, then the authorized clearinghouse would have to be notified, or recognized clearinghouse would have to be notified. This is also an amendment after the introduction of the concept of market participants.
Let's move on to Section 336. Section 336 requires the listed corporations to keep register of interest in shares and short positions. As for the this is a provision on where the register should be kept. There will be certificated and uncertificated registers. This is to clarify which part of the register is referred to. We have added 14A. For the purposes of Section 10A, 1 and 2, if any shares in the corporation are participating shares, a reference to the corporation's register of members, and this subsection is a reference to its members' register certificated shares. As for the members' register certificated shares, in relation to a corporation means the register required under the Uncertificated Securities Market Rules to be kept by the corporation in respect of the members who hold shares in the corporation that are in certificated form. Participating shares means shares that are permitted by the system operator of an uncertificated securities market system to be transferred through the system. These are just technical amendments. Any questions or comments? Let's move on. We now move on to Schedule 1. Schedule 1, this part is the interpretation of the ordinance. We add a definition, we add definitions in response to the introduction of USM. Say in article, we add the concept of system participants. If it is a system participant, if the clearinghouse is also a system operator, then it will also regulate this system participant. And we have also added 11A, the operation maintenance of the uncertificated securities market system that it operates. We've also added new definitions in response to previous provisions, or provisions above, such as system operator, system participant, uncertificated securities market rules, uncertificated securities market system. And they are added in response to other provisions. In terms of major principles, it is in 1AB. how to determine whether securities are in uncertificated form or in certificated form. Now, any securities that is registered, any securities that are registered and transferred under the USM rules, then it is regarded as uncertificated. Other than that, they are certificated in certificated form. As for 1AC, it specifies who is a system participant. A person is a system participant if the person is permitted by the rules of a system operator made under Section 41AB of the Ordinance to send, receive authenticated instructions by or through an uncertificated security market system. Section 14, the commencement date of subsidiary legislation, that's a technical amendment. The subsidiary legislation enacted under the ordinance will commence operation on a date announced in the Gazette. And the different dates can be appointed. Different notices may fix different dates, days for provision to come into operation for different purposes. This is just to provide flexibility. In the future, subsidiary legislation will have a lot of technical details, and we need the flexibility. That's purely technical. Okay, no questions. Move on, please. Schedule 2, no delegable functions of the Commission. That is, these functions cannot be delegated. Now, we have added the functions to the SFC because of USM. Say, for example, from 68A to 68F, these are the functions, including approving a recognized clearinghouse to operate and maintain an USMS, approve a recognized clearinghouse to impose certain conditions in operating a USMS, give a clearinghouse right to be heard. That is about termination of the approval. 68D deals with the amendment or revocation of a condition. 68E deals with the withdrawal of an approval granted to a recognized clearinghouse for operating and maintaining an USMS. 68F is the power to direct a recognized clearinghouse to cease to operate or maintain a certificated securities market system, or to cease to provide or operate any other facilities. These are rather important functions, and the Commission, therefore, cannot delegate such functions to other bodies. Do members have any questions up till now? If you don't have, then we move on. Schedule 3A. Classes of descriptions of securities, i.e., the securities that will be incorporated into the USMS. And we have only added one thing, that is shares. We believe that we have to give some time to the markets to adjust. So the first thing we add is shares. And this is a major concern of the market. As for other types of securities, that unit trusts, debentures, are not included for the time being. Mr. Sin Chung Kai. Now you've just added shares. Now we don't have A shares. We don't have too many A shares, B shares, but are they included? I don't know whether it's the Shanghai Hong Kong Stock Connect will have any relation with this. You just had shares. Does it cover everything? All shares? Does it cover all kinds of shares? The administration. We have to designate what type of shares will be incorporated into the system. We do not at one go include all kinds of shares into the system. We are doing it in batches. First of all, there will be companies listed in Hong Kong. If they are registered in Hong Kong, the matter is simple. But some companies may not be registered in Hong Kong. They may be registered overseas or in the mainland. Their laws may have certain restrictions so that they cannot be incorporated into the USMS. And we therefore have to talk to the relevant supervisory authorities on things to be done. That may involve amending the laws or rules of the overseas jurisdiction. When this arises, then these shares can only be incorporated into the system sometime later. We have already started discussion with the mainland, the UK, and we are now considering Cayman Islands, Bermuda. They are rather popular places of registration, company registration. And we want to incorporate as many companies as possible at the start. But if we are not able, if some are excluded, we hope that they will be incorporated later. As for the Shanghai-Hong Kong Connect, Hong Kong people can buy shares listed in the Shanghai Exchange. If the shares are not listed in Hong Kong, in the Hong Kong Stock Exchange, the system will not cover those shares. In fact, the mainland is now operating an USMS. After with our USMS, we will be at par with them. Now, concerning, well, you have not answered my question. Concerning A shares, B shares, all types of shares. If there are different types of shares, can the word shares incorporate everything or include everything? Shares can include different types of shares. In the first phase, what will be included will have to be designated separately. Can you be more specific? What do you mean by further specification? By what means? Maybe the SFC can help in giving an answer.
Explain a bit. You mentioned A shares and B shares. They're actually different classes of shares, and both come under the definition of shares because there's a very broad definition of shares in the SFO. As to which particular companies would be subject to the new USM regime, we need to think of a way to sort of get them in a sequence. We have yet to consider how to sequence that. We don't intend to sequence it in legislation because it wouldn't make sense, for example, in the legislation to say, right, Hang Seng Bank, CLP or whatever. So we will have to think of a different way to do it. One of the things we're looking at is possibly doing it through the exchange rules. Another option that we could look at is to do it through conditions that the SFC can impose on a system operator. So there are different possibilities that we could look at, but it wouldn't be part of legislation.
Any questions from other members? If not, then we move on. Amendment to Section 134. Yes, please. We have, in fact, completed the amendments to the SFO. Yes, if I may go back to the previous question. Now, Schedule 3A, you just put in the word shares. Very simple. Say, for example, you may work through the exchange rules in corporates some of the companies. But the company may have different classes of shares. Say there are several classes of shares, and only one class will be included, or will all three classes be?
We have two classes of shares. If it did, then we would just prescribe it separately. Prescribe in the sense that whichever mechanism we use, whether it's by conditions or in the rules or whatever, we would just define it in such a way that it allows for one class to be covered and not the other.
咁最後呢一個嘅權
At the end of the day, would the power rest with the SFC?
Rules have to be approved by the SFC, so ultimately it would be in the hands of the SFC.
OK
Okay. Shall we move on? Thank you, Chairman. We are now looking at the company's ordinance, Part 3 of the bill. If I may first speak in general terms with regard to the amendments to the company's ordinance. The amendments to the company's ordinance cover several categories. So the requirement to keep members' register, that will be amended so that the members' register will be divided into two parts. One deals with U.S. uncertificated securities, and that requires a system operator to keep such a register. The other is to deal with certificated shares, and that will be kept by the listed company. As for details for the register, they are put under the subsidiary legislation of the SFO.
And also for the inspection of members' register and the right of access, the relevant provisions will also be amended. As for the details, they will also be in the subsidiary legislation. As for paper certificates and paper instruments of transfer, they will also be amended so as to facilitate the issue and transfer of uncertificated securities. And also for listed companies, now the allotment, transfer, and transmission rules, and this will also be amended because for some of the members' register will not be kept by listed companies. So it is inappropriate to ask them to input the relevant information. The listed companies' responsibilities would be to notify the system operators. Let us now start with interpretation. We will be adding definitions concerning USM. For example, members register certificated shares, uncertificated shares, non-participating company, participating shares, register of members, system operator, uncertificated securities market rules, uncertificated market securities market system. Some of the definitions would be cross-referenced with the relevant provisions, including the meanings given by sections of the SFO. (3)A is, for the purposes of this ordinance, A, any share in a company is in uncertificated form if the title to it, 1, is under the uncertificated securities market rules, recorded by or through an uncertificated securities market system operated and maintained by its system operator, and 2, is under the rules permitted to be transferred without an instrument through the system. Then it will be regarded as uncertificated. B, any share in a company is in certificated form if it is not in uncertificated form. For this clause, well, earlier on we talked about the SFO, and this is related to Schedule 1, 1AB. this definition is in line with that definition. At the company's ordinance, we just repeat it. Any questions? If not, let's move on. Clause 134, nature and transferability of shares. A share or other interest of a member in a company is transferable in accordance with the company's articles. Clause 21 is to amend Section 134. That is subject to subsection 3 and Part 3A of the SFO and the Uncertificated Securities Market rules. The share or other interest of a member in a company can be transferable. And then Section 137 of the company's ordinance, share certificates to be proof of title in the absence of contrary evidence. So it's applicable to both participating and non-participating companies. We are adding a note here. See also Section 635. As for 635, that is, in the absence of evidence, the register can be approved. We are adding this note so that the reader can understand it more. Okay, Section 143. It is about registration of allotments. A company must register an allotment of shares. Now, under the new regime, for non-participating companies, the relevant rules are quite different from the participating companies. So we are amending Section 143 so that it's only applicable to non-participating companies. Here we can see A, B, C, D, 4 subclauses. So they are added so as to make the reading clearer. Well, for Section 623, 2 and 3, the information therein is repeated here. That's no concrete change. As for non-participating company, is a company issuing certificated securities. As for the new rules, is under 143A is about participating company. As for the allotment of uncertificated securities, is under 1, 2, and 4. These are the details. Well, for participating companies, it must, by notice given to the system operator, request the system operator to register under the Uncertificated Securities Market rules an allotment of shares that are to be in uncertificated form. The relevant details set out in the rules. 143A bracket 3. A participating company must register an allotment of any other shares as soon as practicable, etc. And for A, B, C, D, if you look at 143A, B, C, D, they are actually the same. That is, for the certificated shares, the rules are the same, and for the uncertificated shares, they will be in the future rules. So clause 4, penalty. If you look at 143 brackets 2, you will know the fines are the same. Okay, up to now, any comments, members? We have looked at a number of provisions already. If not, let's move on. 143B. Power of court in relation to non-compliance with Section 143A bracket 1. For the new clause 143B, it empowers the Court of Instance certain power. That is, if certain companies do not comply with Section 143A1, then the court can make certain orders. Now, why do we have to include this provision? When we drafted the bill, we have consulted the Bar Association. We have sent them the draft of the bill. For this provision, well, actually suggested by the Bar Association. Because of that, we have added this. Now, if a participating company refuses to send a notification to the operator other than the penalty set out under 143A, the association suggests that an order can be applied from the court so as to instruct the company to serve a notice to the operator. Now, this is similar to Section 145. This is added in accordance with the view of the Bar Association. Let's move on to Section 144. 144, issue of share certificates on allotment. Within 2 months after an allotment of shares, a company must complete the certificates for the shares and have the certificates ready for delivery. The bill amends this section. This section does not apply if the conditions of issue of the shares provide otherwise or the allotment is an allotment of shares to which Section 143A1 applies. That is about participating companies. This is not applicable because there will no longer be paper certificates. One five zero. Requirement for instruments of transfer. A company must not register a transfer of shares in a company unless a proper instrument of transfer has been delivered to the company. We now add a new subsection so that subsection 1 does not apply to a transfer of participating shares effected under the uncertificated securities market rules. This is about instruments, so now we have taken it out and it's not applicable to USM. Next, 151. Registration of transfer or refusal of registration. The transferee or transferor of shares in a company may lodge the instrument of transfer mentioned in Section 105, bracket 1 with the company. 152, order of court for registration. Our bill restricts the authority so that it's only applicable to a transfer under Section 151. Okay, 153, transfer by personal representatives. Our legal advisor has a question concerning Section 152. Thank you, Chairman. For 152, we can see a note for the power of the court to make an order for the registration or transfer of participating shares effected under the uncertificated securities market rules. See the rules. So for 152 is about the court of first instance, is about the registration of shares of a company. And here you've taken out the USM. Well, for giving power to the court is usually done in the primary legislation, but why do you have to take it out and you ask people to look at the USM rules? And also for 101 AAO, it has not mentioned that the courts can be empowered in this way. So when you make the rules, there may not be a strong enough foundation for giving power to the courts. It's not as strong if you do that empowerment in the principal legislation.
Concerning the transfer of certificated shares, Section 151 still applies as other forms of transfer. Say, for example, transfer from uncertificated between uncertificated and certificated shares. Then in the empowering provisions, the details can be provided for under the relevant rules. Apart from transfer between certificate shares and certificate shares, other transfers are under the rules, and so they will be specified under the same rule. Apart from shares of Hong Kong companies, there will also be shares of non-Hong Kong companies. The Companies Ordinance mainly covers Hong Kong companies, but our regime doesn't just cover Hong Kong companies only. Specifying the procedures under the rules will be more appropriate. Therefore, under the Companies Ordinance, we exclude the relevant provisions and then put them under the SFO. And the details will be specified under the rules. Under the new 101 AAO1, the SFC will be empowered to set rules to empower or to enable the court to make orders in respect of the transfer of shares. Under 101 AAO2B, the rules can be for the purpose of registration of specified shares or unspecified shares, and also for the transmission or transfer, and also for the registration of the owners, and also other documents or records. We believe that the relevant provisions are adequate to enable the Court of Instance to issue orders. Legal advisor. Now, under 152, concerning the order of the court concerning Hong Kong companies, that can be put under 152 as for shares of overseas companies which are uncertificated securities that can be set out in another part of the rules. That's for the subcommittee to consider, or for the Bills Committee to consider. Let's move on to 155. 155 requires the company to complete the certificates of its shares that are transferred and have the certificates ready for delivery. The amendment is that this provision, which relates to share certificates, is not applicable to the transfer of participated shares under the USM rules. Any comments? If not, then we move on to 158, Section 158. Section 158 deals with registration or refusal of registration for shares which are transmitted. We propose to amend Section 158 so that it can only apply to non-participating companies. As for participating companies, they are looked after under 158 capital A. Capital A1 corresponds to the existing Section 158(1). Subsections 2 and 3 correspond with the existing 158 subsection 2 and 3. They deal with the scriptless or uncertificated situation. A notice will be issued indicating that the holding of shares is in an uncertificated form. Next, it deals with the certificated situation. A participating company has two parts of the registers. So we just specify the certificated situation and uncertificated situation. Subsections 5, 6, 7, the new subsections 5, 6, 7 deal with the refusal to register. Subsection 5 corresponds to 3 of 158, and subsection 6 corresponds with subsection 4 of 158. Now, if the refusal is in respect of a certificated security or certificated share, and then it is in 158, which corresponds with existing 158(4). Subsection 9 is about the penalty, which corresponds with subsection 5 of 158. Any comments? If not, we move on to Section 159. Thank you, Chairman. Section 159 deals with an order issued by the Court of First Instance if the refusal, the person who has got a refusal can go to the court to make an application. If the court is satisfied, then the company can be ordered to register a person as a member, registered member. A deals with the non-participating companies. B and C deal with the participating companies. B deals with the members register uncertificated shares, and C deals with the certificated shares of the participating company. Good. Next, adding 626A and 626B. The new 626A requires a company to keep a register of its members. 626B requires that the register of members of a participating company is to consist of members of registered certificated shares and uncertificated shares. 627 deals with any member of the company, but the amendment will restrict it to non-participating companies. The wording is the same, but the scope is limited to non-participating companies. Right. If there is no comment, then we move on. The new 627A. 627A is to provide for exceptions under 627. When a participating company changes to a non-participating company, then 627A applies. Maybe a little bit of background. The uncertificated system is applicable to all listed companies. The registered clearinghouse will operate a system. When a company if a company is delisted, then the company cannot participate in the USMS. Now, if it is a participating therefore, the uncertificated shares register will be kept or are kept by the system operator, and therefore something has to be done. And should the information be transferred to the register, that's the situation to be dealt with by 627A. Details are provided in subsection 2. Say if a company changes from a participating company into a non-participating company, unless those particulars are required under the USM rules, as in force immediately before the change to be kept or included in the register, then 6272 and subsection 3 does not require any particulars related to an event that took place or fact that existed before change to be entered in the register of members of company. Okay, 628. 628 is about the place where the register must be kept. We limit the scope to just for the non-participating company. It's about a place. It's about the books of registers. So that can only be applicable to non-participating companies. As for participating companies, they will be specified under the USMS rules. Six to nine is in relation to a company which has only one member. We specify that this can only apply to a non-participating company. As for the participating companies, they will be dealt with under the USM rules. Right, we move on. 630. 630 is about the index of members. We apply this only to non-participating companies. The requirements for participating companies will be in the USM rules. By the same token, 631, which deals with the right to inspect and request copies, will apply to non-participating companies only. 632 then. 632 is the same. It will only apply to non-participating companies. Details for participating companies will be provided for under the USM rules. 633 then. 633 deals with the power of the court to rectify a register. The bill will impose restrictions on such powers. If there is any loss caused by an act or omission of the system operator responsible for keeping the members' register of the uncertificated shares of the company, the court will only be allowed to issue order to require the company to pay damages. And the conditions that the act or omission is done or made by the system operator on the instruction of the company, and the act or omission is caused by fraud or negligence of the company. Legal advisor. Thank you, Chairman. The question is similar. I've noticed that in a note as to whether the court has the power to order participating company or any other person to pay damages for any loss caused by any other act or omission of a system operator, see the Uncertificated Securities Market Rules. The question is, in fact, the same. Now, it will be clearer if it is put under the Principal Ordinance 633. Under 101 AAO, it doesn't mention the arrangement for damages in respect of participating companies. As for the register of a participating company, there is the certificated part and the uncertificated part. As for the detailed requirements, we believe that it is more appropriate to deal with it under the USM rules, which will be more comprehensive. Under 101 AAO 2K, we have confirmed that the rights, duties, and liabilities, including exemption for liability of persons mentioned in paragraph J. Yes, follow up. Thank you, Chairman. The reply by the administration is that K, if you look at K, the rights, duties, and liabilities, including exemption for liabilities of persons mentioned in paragraph J. If you look at J, J deals with persons in H. And then if you look at J, then you have to jump to H. As for H, I've asked the administration, also the SFC, whether H includes the company allotting the shares. The answer is it does not. It does not. The participating company is the company which allots shares. If H doesn't include that, then your argument is problematic. Noakes. The Noakes says that it includes ordering the participating company to pay damages, but H doesn't include the participating company. So it doesn't empower the court to make orders in respect of damages. So if you say it is based on I, H, and K, that is not appropriate. People may challenge that there is no such empowerment. Ms. Chen.
Maybe SFC can answer this question. Who would answer this question, please?
It's going to go. The idea was that when we talk about the liability of the company, we leave that provision in the bill, in the company's ordinance. And so the way it currently reads is the idea of the addition in Section 633 is that the court is not supposed to be awarding damages against the company where the fault is the fault of the system operator. And in terms of awarding any damages against the system operator, that would be provided in the rules. But I take your point that the note actually says as to whether the court has power to order a participating company to pay damages. That would be provided in the USM rules. And you're right, we did not intend H to, is it H? K, we did not intend K to cover companies.
Chairman, maybe I can supplement. For USM rules, 101A01 actually is very broad. And for 2, as I mentioned just now, is about details, but for 1 is very broad. And it can cover a lot of things. For example, issue, holding, entitlements, etc. So all it covers all this. And for 2 is the details. 2 is not limiting the principles of 1. Legal advisor. Yes, I agree that 1 is broad. But if you want a company to make compensation, then it affects the interests of the company. So we need a clear legal base for that. If we look at 1, I don't see any clause that is broad enough. That is to allow the courts to make such an order. So we need specific provisions to do that. If you use 1A, I don't think that's very appropriate. Yes, I would like to thank the legal advisor for his views. We will go back and revisit this provision. Okay, let's move on. 637. 637 is keeping of branch register. Now we are amending it so that it only applies to non-participating company. And for participating companies, they will be regulated under 637 big A. Well, for this clause, actually it's very similar to the situation of non-participating companies. It's almost the same. Then let's continue. 654. Meaning of company or records. The bill broadens the definition so that it also covers the uncertificated securities market rules. So this is a relevant amendment. Okay, 655. It's also a consequential amendment. We add all the rules. Okay, 696. Obligations of offerer with rights to buy out minority shareholders. 3A2, an instrument of transfer of the shares, while the offerer must send to the company an instrument of transfer of the shares to which the notice relates, executed on behalf of the holder of the shares by a person appointed by the offerer. In the future, there will be the USM regime, and so there will be no instrument of transfer involved. So we are now taking this out. This is a consequential amendment. Okay, 908. Thank you, Chairman. Section 908 is about paperless holding and transfer of shares and debentures. Schedule 8 is amendments relating to paperless holding and transfer of shares and debentures. So for all these provisions, for example, Schedule 8 was added in 2010. The reason for adding this was to show the government's support of implementation of paperless arrangements in the market. And at that time, the government already said that such rules would have, or such provisions would have to be further amended. And our bill covers part of the contents of Schedule 8, and we have made the relevant amendments. So for this added part, we will be deleting it now. Okay, next. Chairman. Then we will be looking at some other related amendments. And for stamp duty ordinance, because I hope that I can ask the Inland Revenue Department to send representatives here to explain about these provisions, so I'm not going to talk about them. Okay, Part 4, related amendments. Division 1, amendments to companies winding up rules. For Clause 51, it is to amend Table 70 or Form 73. This is a notice of return to contributories, because there's a mention of share certificates in the future. With the USM regime, there will not be such a share certificate. So we've made some consequential, some related amendments. If it is in uncertificated form, then within the meaning of Section 23AA of the Companies Ordinance, the evidence of your title to shares provided for under the uncertificated securities market rules. This is A, and B, if the share is not in uncertificated form, the share certificate. So for the stamp duty ordinance, we will talk about it next time. So for this meeting, we can talk about the other amendments. The Secretariat has issued a marked up copy. And now we should move on to page 108. That's the Chinese version. And 107 in the English version. That's amending the mental health ordinance. Okay, let us look at this part first. Yes, thank you, Chairman. Well, originally the provision just took care of certificated scenario, and now we've added something so that an uncertificated scenario can also be handled, and we are also making the wording simpler. This section applies if the court makes any of the following orders. A. An order for conveyance or instrument of transfer to be executed in respect of a disposition of the estate of a mentally incapacitated person. So this is a certificated scenario. As for uncertificated scenario, B, an order for any other thing to be done to give effect to a disposition of any securities in the estate that are under the USM rules permitted to be transferred without an instrument. And then Division 4, amendments to Crimes Ordinance, Section 84. In the original provision, there is mention of shares or stock transferable by any deed or written instrument. Because in the future we will have a USM regime, so we are adding this scenario, that is any transferable share or stock. And under 2B, we say that any share or stock transferable without an instrument under the USM rules. Okay, Division 5. Section 632. This division is to make amendments to company's ordinance, and it's about commencement date. And Clause 41 amends Section 632 brackets 2. It's about non-participating companies, and it's as to what will happen to listed companies, non-listed companies, etc. So if all the listed companies become participating companies, then Clause 41 will no longer be applicable, because all the members registered will be governed by USM rules. Then we will have to use the version stated under Clause 61. So for Clause 61 is put in Part 4, related amendments. Then these two provisions will take effect on different dates.
Shall we move on? Concerning the bill, apart from those related to the stamp duty ordinance, we have already completed the study. So we'll leave it to the next time when we discuss stamp duty. So have we finished? Are there any comments or questions? All right. Well, we're very efficient today, and we've gone through so many provisions. Okay, we end here. Thank you very much. Thank you. We move on. Next item on the agenda. Date of next meeting. The 2nd of January, Friday. 10:45 a.m. 10:45 a.m. The 2nd of January, 2015. Thank you, Mr. Chan Kam Lam. You stay with us all the time. All right. Meeting adjourned. Thank you.